We are starting into session 3 of our interactive process here. I've already covered a general overview of the ADA and the FMLA, and I also did a much more extensive review of the ADA in our last session. In the third session, I'm going to be focusing more on the Family and Medical Leave Act and its requirements upon an employer, so that we can then go into the nitty-gritty of the interaction between these two important statutes. When we talk about Family and Medical Leave Act, an individual has to be an employee. And when we talk about an eligible employee, they have to have been employed by your organization for at least 12 months. The definition of that 12 months is not an anniversary date. We look at any time that the employee has worked for your organization in the past 7 years and add that up, and if it adds up to 12 months, then the individual has met the first requirement of being an eligible employee. The second requirement of being an eligible employee, they must have worked for you at least 1,250 hours in the past 12 months prior to the qualifying event. So if they had a qualifying event today, you would look at the past 12 months, add up the time that they worked for you in the past 12 months, and if that adds up to 1,250 hours, then they would have met the second part of the requirement to be an eligible employee. When we add up the 1,250 hours, we use the same hours that we would consider hours worked under the Fair Labor Standards Act. So again, it's very important here that you have kept accurate records of all hours worked, and do keep in mind that eligible employees can be non-exempt as well as exempt employees, and traditionally you only keep hours worked or keep a record of hours worked for your non-exempt employees. But due to this part of the Family and Medical Leave Act, you may want to consider some process by which your exempt employees are also reporting the hours worked that they are working for your organization. The third part of the definition is that they must work at a work site where there are 50 or more employees within a 75-mile radius of the work site. This part of the employers, because if they meet the definition of being a covered employer, and that means that they have employees. When they do have individual work sites where they have a small number of employees, they feel that it is a little bit of a morale issue to allow FMLA leave for the home office, if you will, but not allowing it for those satellite offices where they may not meet the employee requirement. But that is very much a business decision for an organization to make. With regard to FMLA, an individual is allowed up to 12 weeks of leave in a 12-month period. You as an employer have an absolute right to define your 12-month period. It can be a calendar year, a fiscal year, a rolling forward, or a rolling back. Most often I see the rolling forward or the rolling back method. Those are the two methods that are the most advantageous to the employer. When we talk about the availability of leave under the FMLA, the individual is entitled to that leave for the childbirth and care for a newborn, adoption, foster care, or placement, the inability to perform the job functions due to a serious health condition. And we are looking at the same term that we use in the ADA, that they are unable to perform the essential functions of their job, or they're required to care for a family member with a serious health condition, or qualifying exigencies due to a family member's active duty or call to duty. And of course, as I said, they get up to 26 weeks to care for a service member who has been injured or contracted an illness in the line of duty. With regard to this type of leave, as I said, that we are focusing, when we talk about the interaction, usually the leave of absence that would be required for an employee due to their inability to perform the essential functions of the job, and that is obviously what triggers the ADA as well. I do want to just briefly talk about the leave that is required under the FMLA to deal with a serious health condition of a child or a family member. Again, that is required under the FMLA, but there is no accommodation requirements for an employee who has a family member who may have a disability. The employer, what we call associational disability, the employer cannot discriminate against an employee who has a family member with a disability, meaning that you couldn't refuse to hire them or discipline them because you may, for example, fear that the family member's disability would increase your health insurance premiums, but you would not be required to accommodate absences that that employee may need due to a family member's disability. But under the FMLA, you would be required to accommodate those absences because that would be a leave that was necessary to deal with a serious health condition of a family member as long as that employee is an eligible employee. Serious health condition, it is very specifically defined under the regulations, and I do suggest that you ignore labels and do look at the definition under the regulations to determine whether someone does have a serious health condition that you would need to provide some type of leave for them. We look at inpatient care and any subsequent treatment dealing with that inpatient care. And that just does mean that even a one-night stay in the hospital would qualify for potential leave under the FMLA. The big one that we tend to litigate a lot is when we talk about an incapacity of greater than 3 consecutive days. That is not working days, it's 3 consecutive calendar days. And any subsequent treatment associated with that incapacity, like physical therapy. We also look at any time off due to an incapacity due to pregnancy or even the need to take time off dealing with prenatal visits, morning sickness, or the like. Any incapacity due to a chronic condition like asthma, again, with regard to any incapacity, it does not have to be an incapacity of greater than 3 consecutive calendar days. It could be a very small time, as small as 15 or 30 minutes, that someone may need some time off due to a chronic condition. It could also mean a permanent or long-term incapacity, and in any absence to receive multiple treatments. For example, like physical therapy that someone may need 3 times a week dealing with some type of an injury or the like. When we talk about the FMLA, there are 2 aspects of it. You cannot interfere with an individual's rights to take an FMLA leave, meaning that you have to provide them with that leave when necessary, but you also cannot retaliate against them for taking leave. And with regard to retaliation, there are a number of factors that a court will look to determine whether there is evidence that you have retaliated against someone for taking leave. They will look at whether you knew or that the decision maker knew the fact that they had asked for FMLA leave or had taken it. They will also look at whether there was any type of a negative attitude toward the employee's injured condition, their serious health condition, or the disability. They will also look at whether you deviated from company policy when you did discipline someone who may have made a workers' comp claim or asked for an FMLA leave or who is disabled. They also look at discriminatory treatment, comparing that individual to the treatment of other individuals with the same issue or a substantially similar one. And timing is always a factor that's also very, very difficult for an employer. Frequently, the employer may find job performance issues that they were unaware of. They find out about it during a leave of absence, or they find out about some serious misconduct that an individual may have done. They find out about it while they are on that leave of absence, and then they want to take action. And obviously, the timing in that situation is not great. And but it doesn't mean that your hands would be tied. You just have to tread very carefully and make sure you document accordingly why you are making the decisions that you are doing. When we talk about FMLA leave, and we look at the interaction again with the ADA, the FMLA does have written into it a 12-week requirement. The ADA, however, does not have any type of set time period written into its statute. We're looking at essentially what would be considered an undue hardship upon your organization. The Robert versus Board of County Commissioner Brown case out of the 10th Circuit that came out in the 10th Circuit in 2012 is a good case where we talk about an employer, getting into trouble because they were really trying to be nice to their employee. It's no better place than in employment law for the adage that no good deed goes unpunished. In the Robert case, the individual had supervised adult offenders, and she had been in and out of work for several years. And due to the fact that she had a condition that the employer did allow her to work from home, and telecommuting can be considered a reasonable accommodation. At times, the employer would even relieve her of the essential job functions, and this is where the employer had gotten into trouble, was lowering his job expectations and lowering his job requirements, and that's what the employer did here. They relieved her of some of her job functions, and but when she was unable to return at the end of her later leave, the county had terminated her employment. And she said, well, wait a minute, these job functions that you are claiming to be essential cannot be really essential because you allowed me not, I mean, there were situations where you said I did not have to perform these essential job functions. And the court said, well, wait a minute, this employer was doing this on a temporary basis. He was not permanently eliminating the job functions. And so this was just a temporary excusing of an essential job function, and that did not mean that the job functions were not essential. But you can see here again where the employer got into trouble by the mere fact that they were trying to be accommodating to this employee and lowering the job requirements, and that's where the employer had gotten into trouble here, albeit the court did rule ultimately in the employer's favor. But the employer obviously had to pay probably a significant amount of attorney's fees to get to that decision. Dealing with the Robert case again, the court did talk about, when we talk about the terms of leave, and again this can be beyond the 12-week requirement under the FMLA, the court said we consider two issues to determine whether any type of leave beyond what is required under the FMLA would be considered reasonable. And the court looks at when will the employee be able to do her job. As I said in the first session of this podcast, when we talk about the differences between the ADA and the FMLA, there is an inherent assumption under the FMLA that the individual is unable to perform the essential functions of their job, and therefore, and actually that's the requirement, and therefore they need leave due to their inability to perform those essential functions of their job. The goal of the ADA, however, is that we're looking at what is necessary so that the individual is able to perform the essential functions of the job. So when we talk about whether a leave of absence would be considered a reasonable accommodation under the ADA, we do very much look at when will the individual be able to do her job. And the court says that there has to be some type of an estimated date when they will be able to perform the essential functions of their job. Almost every court, and I think every court that I'm aware of, will say that a request for an indefinite leave of absence is an undue hardship because employers cannot evaluate what the true request of the employee is in that situation. And when we talk about the estimated date, the 10th Circuit said that we look at how long it is. The court does note that there is nothing in the statute that talks about how long that leave might be, although there has been several court decisions trying to determine whether a 6-month leave would be considered a reasonable accommodation. I know a number of companies will have what we call these inflexible leave policies where they would refuse to continue a leave of absence beyond 6 months or beyond a year, and a number of courts have upheld these inflexible leave policies. I do caution you, however, that these inflexible leave policies are a hot button issue for the EOC, and they believe that the EOC believes that the inflexible leave policies violate the ADA because it does not require the employer to engage in that interactive process and look at the individual's particular circumstances and whether that employer can address those particular circumstances without that undue hardship. But the courts in large part have been upholding some of these inflexible leave policies anywhere from 6 months to a year. Again, another case dealing with inflexible leave policies coming out of Kansas State University, a very recent one out of 2014. The plaintiff in this case had used all of her 6 months of leave under the employer's inflexible leave policy, and again you could see this leave policy exceeded the 12-week requirement under the FMLA. She asked for additional leave beyond the 6 months, and the employer refused to provide her with that additional leave. And she basically said that, well, that's a violation of the ADA because it would have been a reasonable accommodation to continue my leave beyond the 6 months. The court said no. They basically said that 6 months was enough leave, and if an individual is unable to come back to their job functions or be able to perform the essential functions of their job at the end of those 6 months, that was enough leave that would be that is enough leave that the ADA would require an employer to give to an employee as part of that accommodation. Again, as I said, that's a hot button issue for the EEOC. Dealing with the more recent case here, but there's some language in this case that's very good for an employer. The court said, must an employer allow employees more than 6 months sick leave or face liability? And the court said, unsurprisingly, the answer is almost always no. And of course, what the court was focusing again was talking about what I had said earlier with regard to what is the goal of the ADA. It is to provide those accommodations that does allow the individual to come back to work and perform the essential functions of the job. And the big thing that was the language here that was very employer-friendly and focuses on that aspect of the goal of the ADA is when the court said the reasonable accommodations are all about enabling people to work, not to not work. And I know that's a little wordy, but that is a direct quote from the court decision. So we talk about inflexible leave policies. As I said, this is not something that the EEOC likes, and it is a hot button issue for them. And the EEOC has sued a number of companies dealing with their inflexible leave policies and have actually had some settlements with regard to their lawsuits that they have brought against companies due to their inflexible leave policies. On one particular case, an employer had paid $1.35 million dealing with the inflexible leave policy and actually agreed not to have the same policy that the court had upheld in the 2014 case. In that particular case, the employer had provided its employees up to 12 weeks of leave, the maximum that was allowed under the FMLA, but would not allow an employee to allow an employee a leave of absence beyond 6 months. And of course, the EEOC said that violated the ADA and was able to get a significant settlement with the employer. Press releases from the EEOC do note that employers have paid more than $35 million to resolve lawsuits that the EEOC has brought against employers dealing with leave and attendance policies and whether they do violate the ADA. More recently, on July 10, 2014, the EEOC sued another employer for having an inflexible leave policy where they would not provide a leave beyond 4 months. And the lawsuit, which has not been resolved at this point, but the EEOC found issue with this inflexible leave policy, particularly noting that the employer's doctor had stated that she would be able to return to work without restrictions in less than 2 months. So that is a case to be on the lookout for and to see what the EEOC may do with that particular inflexible leave policies. This would be a good time to end up our third session, and we will pick back up dealing with attendance issues and under the ADA and the FMLA.